Thanks. Welcome to Sports and the Law Chapters 1 and 2, update video outline. This is the way we're going to proceed each week. We're going to give you our update links. We're going to walk you and talk you through them with help from our teaching assistants. Caroline, thanks for being here, Alexander, and Aaron Caputo, with whom I've taught this course many times before, and a strong many-year colleague of mine over at Modus LLC. So getting right into it as part of the course in preview, and updating the links that are in the book, and everything plays off of that which is in the book. So we're going to be, adverting to and going back to, hey, you're going to want to look at this. Hey, you're going to want to look at that, because this is the legal evolution of America's three major leagues that we're talking about. And the latest evolution, Alexander, we've asked you to be sort of on point for this, is the Deshaun Watson case. We've uploaded the entire opinion. I have it here highlighted. We would expect everybody, hopefully, come to the first and second class. We're combining weeks 1 and 2. To have at least looked at it, to have highlighted it, to have seen what they find interesting in it, because the hypo we're going to work towards is, what if it had not been settled? What should or would have been the result if Mr. Harvey had ruled a delegation of commissioner's authority? Of course, in the NFL, ultimately, Commissioner Goodell is the ultimate authority. He delegated that authority to the other leagues. There's neutral arbitration. That's the one unique factor about the NFL that you'll read about as appeals go to the commissioner still under Article 46, conduct detrimental. But that's what we're dealing with here, Alexander, and thanks for being ready for it, and thanks for helping put together this outline and these links. And I think we all, if we're in this course, have at least heard a little bit about this, and we go all the way to Peter Harvey. But what would you say in terms of Judge Robinson's 6-game discipline? Again, we can read the opinion in its entirety. We see how, hey, there's been 3 games over here for nonviolent sexual assault. There's been 6 is sort of the baseline that we've arrived at. How did you feel for nonviolent sexual assault? You think this was about the right place? You came down about the right place, and probably Mr. Harvey would have just endorsed it, and we would have moved on. What's your best guess? And thanks for being prepared on this.
So the crux of Robinson's 6-game suspension was that it's 2 times the amount that the NFL usually gives to nonviolent offenders. And in the opinion, you can see she found that Watson's conduct was nonviolent as defined under the personal conduct policy. The law of shop, which means just the customs and practices of the NFL regarding suspensions in the past, that was kind of what she based her argument on. You can read other law of shop related cases in Bountygate, Adrian Peterson, Deflategate, suspensions and PED use. It's all over the course book. You'll be able to find a lot of examples of that and kind of come to your own determination as to whether 6 games was the right thing to settle on in light of those practices. In terms of how Judge Harvey would have ruled in response to that, that's a little harder to say because, like you mentioned, Commissioner Goodell is essentially appealing back to himself. Harvey, obviously the proceedings a little bit biased towards the NFL. As Mike McCann says in one of the articles in the first week's Vault Link readings, Goodell doesn't want to overstep his bounds too much, and he'll feel constrained to some extent by Judge Robinson's decision. But we could potentially expect Judge Harvey to have kind of lengthened that suspension because this was an unprecedented act by Watson. The scope of his alleged sexual assault, could be injurious enough to the league such that that conduct detrimental warrants a longer penalty. And again, like Goodell has the authority to impose, a longer penalty than Robinson initially did. And again, reading Deflategate will be helpful in kind of seeing how the whole process plays out.
Thank you. That was perfect prompt. I just bring to the class's attention footnote 51, and the book covers this, but the policy is equally applicable to players, team owners, and management. Hello, right? And the NFLPA, Jeff Kessler, has been a guest for us many times. Whether it's fair and consistent to severely punish Mr. Watson for his nonviolent sexual conduct. When you look at some of the other things that have been going on, no team owners have been charged who have been accused of similar or worse conduct. So I think that there was some sort of equitable sort of let's treat owners and management the same. And we have many links on punishing owners and questionable owner activity. Dan Snyder, Jerry Jones, and Bob Kraft. I think that was the suppressed premise there in footnote 51 on page 15. Okay, anything else? Really good summary. Expect conduct detrimental. Article 46. I know So you don't sue the league. So let's say one side or the other wasn't happy with what Harvey did, you move to vacate the final arbitration award. You don't sue the league. Waiver of recourse is an important theme that runs throughout the course in the Constitution, in the bylaws. Everybody, anybody who's involved with the league, including coaches, we're going to get to that. They have a clause in their contract saying you go to final binding arbitration. And what does it take to upset final binding arbitration, Alexander? Look at Garvey at Supreme Court. It would have to be, the arbitrator would have to have been out of his mind, essentially out of her mind. It would have to have been arbitrary, capricious, have nothing to do with prior precedent. I think the Garvey study guide is instrumental or instructive there. But what about vacating a final arbitration award? Where should the class look to see that almost never happens?
Yeah, I mean, the case in which it did happen was Deflategate initially in the district court,
Right.
and then it got overturned in the circuit. Bountygate's a perfect example to see where it's almost impossible to have a motion to vacate. I remember last year you would say the Second Circuit is where motions to vacate go to die.
Yeah,
and so it really kind of tells you that it's almost impossible to do that. And even if you argue that the process is unfair because the NFL essentially appealed to itself, a court would still have to accept that arrangement because it was collectively bargained. Mike McCann also explains that in his week 1 article. So really all you have to rely on is kind of what's in the evidentiary record and kind of rely on that. But it's almost impossible to vacate one of these arbitration decisions.
And if I could add on to that, I would just say some instances, just if you want to look straight into the course text of this extreme deference to final binding arbitration decisions. Adrian Peterson found on page 324, we have a study guide for him. The Deflategate, like they mentioned, is on page 38. Garvey, which is a huge decision we've referenced a few times, is found on page 113, just if you're looking in the course text.
And thanks, Caroline. And it's really the Federal Arbitration Act, Jeff will talk about, Jeff Pash will talk about, that talks about this, because the unions agreed to it. The union has agreed, right? That's it. Aaron, right? I mean, do you want to add?
Yeah, I'd say look at Ezekiel Elliott as well, if you haven't mentioned him already. And the one thing I wanted to point out to Alexander's point about evidence is that when you're thinking about what Peter Harvey would have done on appeal, is that he's bound to the evidence that was found by Judge Robinson in her initial decision. So when you're thinking about how he could have increased the penalty or amended the discipline, make sure to keep that in mind. But yeah, all good points by everyone in terms of precedent and where to look for materials on motion to vacate arbitration.
One last thing, then we'll move on. I noticed on page 1, I highlighted, Judge Robinson says in paragraph 2, this policy was unilaterally imposed by the NFL. I don't know if that caught anybody else's attention, but it has since been, because they didn't grieve it, it's been agreed, right? I mean, that's really the way I look at it. But initially it was unilaterally imposed, and the union never since then has grieved it. So
Right.
it's in there forever.
And then was amended in this most recent season.
It was amended, and
Right.
they didn't oppose. So
Right.
Okay, Harvey suspended. Manfred's power, commissioner authority in the MLB, different. It goes to final binding arbitration before neutrals, 1 or 3, depending on what the parties want. Suspended 60 games, third of a season, violating. Trevor Bauer, oh my goodness gracious, that's on appeal. Obviously, we know where that goes, not to the commissioner, ultimately on appeal. Again, in all 3 leagues, all these final binding arbitrations, the most anybody could do is be moved to vacate, no suing of the league or the team. Go ahead, who's going to take the lead on these 2 things in our prep session? Is this still you, Alexander, or Harvey?
Yeah, I could speak briefly on it. I think you hit on most of the main points. Once it goes to that neutral arbitration, it goes to it becomes a final binding arbitration at that point. The whole points about motion to vacate that we discussed previously apply here as well. In the MLB, the suspension would be appealed under a just cause standard to an impartial arbitrator. I believe that's what Trevor Bauer is in the midst of trying to do right now. Yeah, so I guess we'll see what happens on the Bauer standpoint as the appeal goes forward.
One thing I'd add for Harvey too is it throws a little bit of there's a bit of a nuance to it in that Matt Harvey didn't test positive for in order to trigger his violation. He testified to it in a trial for death of Tyler Skaggs. So I think that's a bit of a nuance too, is that that's not the only testing positive isn't the only way to violate the program.
Thanks. And we have a whole A-Rod study guide when we get to a later chapter that talks about inability to sue the team or the league in this context, and sort of max suspensions back in the day. Josh Donaldson, one game, terrible stuff. He was referencing an interview, but still, it shows the commissioner's authority, right? I think this is really appealed the decision to no avail. Thank goodness it was the right result for the right reason. A minimum 1 game suspension. Again, and same sorts of themes that run through each of the leagues. This conduct detrimental, whatever you want to call it, best interest of the game, pater familias going all the way back, to Judge Landis having to get control of the major leagues way back when. That's where commissioner's authority starts, giving him almost ultimate authority until the union got it to the point where it's a neutral arbitrator who decides, except the commissioner of baseball can take it out and have it to himself. We'll learn that in the Bowie Kuhn case. Says he should have done that in the Messersmith McNally grievance. Cites ruled against him. That's way down the line. But what does this tell us about how closely the commissioner and the league is looking at each and every factor that comes to his attention during a game? Even the manager, La Russa, is now on sick leave, unfortunately, disrespectful. What does this tell us about? You better be careful what you do during a game.
Yeah, I mean, this is kind of a zero tolerance policy for anything that might be conduct detrimental to the league. That is clearly defined extremely broadly. And, if the commissioner doesn't like something and think it could turn into, a controversy, and obviously, these comments were not great to say the least. And, if he didn't punish him, it could turn into something else. They really look at everything to make sure the league is in good standing from a PR perspective. And any other perspective, no matter how small it may seem, how big it may seem, anything.
Yeah, thank you. And again, you can't have, there's no double jeopardy. If the league hadn't done something to the team, then it falls to the team to decide. We'll get to that when we get to the group hypo, but I'm glad that they intervened here and dealt with it swiftly. Calvin, now gambling is a totally different matter. And you could say, oh, how is that fair? Look, I mean, how is that fair? It's a full season for betting, bets on NFL games, including Falcons games. He's not with the team. He was away for, oh, come on, says Ridley. This is totally unfair. Watson only gets 11 games. How am I out for the whole season? We got Josh Shaw as maybe the other exemplar for a year. We have all sorts of legal evolution of gambling. It is the one thing since the Black Sox scandal, the one thing that the leagues cannot tolerate is gambling in any way, shape, or form. Zero tolerance, as Alexander said. What else do we have to say about that? This is you're dead on arrival, right?
Specific gambling policy for each of the leagues, but again, as soon as there's found to be some sort of violation, you're at press Carfagna, it's dead on arrival, and that is when you're potentially impacting the outcome of a game or have knowledge on the outcome of a game, and you can impact that in any sort of way. That's a no tolerance policy as well, and be punished to the harshest extent allowed.
Yeah, and the union has agreed that. So again, no way out. Okay, then we get to authority sort of conduct detrimental for anybody and everybody. Got Stephen Ross, of course, gets penalized the day after Watson. Timing is everything, right? And we get into that sort of tampering problem, and so team owner was fined, was disciplined. But this whole what must go to final binding arbitration is raised here in the Flores and Gruden cases. And again, without getting into excruciating detail, I think it's fair to say everything should go to arbitration here. I'm quoted in the Gazette as saying it should go to arbitration. I cut some flack for that, but I mean, it's just in everybody's contract. It's in the NFL Constitution. You agree by becoming an employee of the league. And Gruden's only way out is maybe, I wasn't an employee of the league at the time that happened, but if it's still conduct detrimental, you're gonna pay for it, pal. And I think ultimately that one opinion that let it escape arbitration that you'll read about in the Gruden cases, oh, you leaked the emails. I think, the noose is around everybody's neck with the waiver of recourse that's in the Constitution for players and everybody else. Anybody who tries to sue the league, Donald Sterling, whoever tries to sue a team or a league, they're going to final binding arbitration. And that's that. And I think that's what Flores is, I think is going to have to end up there. for reasons I talked about in the Gazette, and I think Gruden ultimately is going to have to end up there. I think that's the point we want to bring in terms of commissioner's authority and waiver of recourse. Waiver of recourse is the other thing that runs throughout the course. But what else in our prep session should we bring to bear on these two cases? And Caroline, you had some particularized parts of the CBA that talked about Rule 46 discipline. Maybe now's the time to drop those in.
Yeah, I think Articles 42 and 46 probably speak most to this issue. I know 42 specifically delineates the instances in which the team itself can deal out like punishments, but 46 is probably more on point. I think in the CBA, it's actually page 245 is where it begins. And like you've mentioned before, just knowing that there can't be double jeopardy. You know, you can't be punishing these players for the same exact action twice. And it's really ultimately up to the commissioner, to the league. But in instances where they want to deal out that authority to the team does have some rights to deal out punishments as well.
The one thing I would add on this.
Yes, thank you.
Yeah, the one thing I would add on the Brian Flores and John Gruden piece too, it's just reiterating how strong the waiver of recourse is. And again, that's included in their agreements and the NFL Constitution and bylaws, which are incorporated by reference into the coaches' agreements as well, which include the waiver of recourse. And so John Gruden, and he tried to make a similar argument to Tom Brady, I'd say, in Deflategate, in that, hey, I wasn't on notice. I never got a copy of the Constitution and bylaws, so I didn't really know this was in the agreement, which I don't think it's going to be successful at all against Deflategate. But so I would just throw that, on top of all that, just another layer of trying to show the importance of the waiver of recourse. And to Professor Carfagna's point, I think both these are going to end up in arbitration.
Yeah, and Deflategate Article 15 of the Uniform Player Contract incorporates by reference the Constitution, bylaws, and conduct detrimental thereby.
Right.
So,
right.
And there's no. You signed the contract, Tom.
Right.
Sorry, you agree to be bound, and same with
Exactly.
with Flores. And I'm not saying Flores' allegations are not really important. Don't get me wrong. I think they're really important. And there's a second Gazette article that talks about what could or would happen if it escaped arbitration. I'm just saying from legal evolution standpoint. And Ross was fined for tampering, not for tanking, right? And what Gruden did was just awful. And he recently tried to apologize. Well, sorry, it's too late for that, pal. But we're talking about words are words, and antiseptic application of these policies and these processes which people agreed to. Is the thread we're trying to that's the needle that we're threading here from a legal evolution. Go ahead. Yeah, Caroline.
If you wanted to just read about like the scope of this conduct detrimental phrase that you're kind of hearing a lot, page 64 and following in the course text also kind of touches on the ability of teams to seek injunctive relief and sue. It's just kind of like the scope and the applicability of these procedures and policies that were collectively bargained.
And it comes out of the case law, which are now all optional readings, where this stuff all used to go to, Lajoie and all the cases that built up to final binding arbitration on every grievance. So every time something escaped, and it's in the optional readings, the cases, all of which escaped final binding arbitration, what you'll see as a theme throughout this course is, well, then they negotiated it. And once it was negotiated between the union and ownership, then it became a matter of collective bargaining, and then everybody agreed it would go to final binding arbitration. But there's a whole lot of legal evolution in our optional syllabus that goes all the way back to where everything went to court, and the unions and ownership have now agreed, and their final binding arbitration says it will stay hermetically sealed within our processes. Okay, guaranteed contracts. What do we have here? Here we go. All right. Setting a new standard. Here we go. What do we have here, Aaron, if you're the host? Okay.
I can take this one. I think this
Go ahead, yes.
This is in your Vault articles. It was written by the Players Association, the NFLPA.
Yes.
And I think it was highlighting how actually none of the CBAs explicitly guarantee contracts across the board for players. But recently, I think, particular to the NFL at least, there's this old rule that like teams must put into escrow the amount of money equal to what they're guaranteeing the player. So that's kind of disincentivize teams from guaranteeing contracts in the NFL. But recently we see something might be a turning point, I guess, with the Browns and Deshaun Watson, just that the Browns did decide to do what other NFL owners and executives have mostly been unwilling to do. And so I think it was a very motivational piece from the PA, hoping that symbolizes a turning point for the NFL.
Yeah, even the lookalike contracts. Who was it? Kyler Murray most recently, maybe. Right, it's not fully guaranteed.
Russell
right?
Wilson yesterday.
Right, Russell Wilson. Right, that's what I was thinking about. Yeah, Russell Wilson. Yeah, it's not fully guaranteed, and the other teams are mad at the Browns, right, for fully guaranteed, because now what does Lamar Jackson do? I think he represents himself. I think he does. I don't know that he has an agent. But
Yeah,
anyway,
that's true. I don't think he has a registered agent.
Yeah. All right, this Mike Zarin will deal with in week 1. We'll talk about it, but we won't talk about it. Again, is the point we're making here again? Something that must go to final binding arbitration, and even though it's a mental health issue, it can't escape. We sound like we're repeating ourselves a little bit, but go ahead, whoever wants to take the lead on this. It sort of speaks for itself.
Yeah, just the one nuanced point here is the leagues have different standards of review for when these go to appeal. The NBA applies a just cause, or it's a little confusing, the NBA specifically, because they apply a just cause standard for all these grievances, but in certain instances, most notably in domestic violence cases, the standard then changes from just cause to arbitrary and capricious, but it's not totally clear which one is supposed to apply, because they do say just cause applies to all of these grievances. But I believe in the Simmons case, any appeal would be under a just cause standard. So a little bit of a stricter standard than we've been discussing for Deshaun Watson and kind of these domestic violence cases.
Terrific.
And I will add that
yes.
on page 8 and following, kind of in the course text, we'll talk a little bit more about the NBA's arbitration process from what you haven't learned here.
Terrific. Getting near the end here, Randy Gregory flips. This is usually the UPC is the UPC, but there can be negotiations on that get added that are addenda, and the salary forfeiture language allowed him to have an out from the UPC, which is very, very rare. I think that's what this is trying to teach us. Let's see, he's voiding his contract if he's fined or suspended for any drug offense. Who wants to?
Yeah, I would just add, I think what I'd say is, right, there's a lot of times there's addendums added to the UPC, which add additional terms to the standard UPC language. And here, this is a term that is not included. I wouldn't say it's standard amongst NFL teams, the ability to void the agreement if the player is fined or suspended for the NFL's PCP, at least to the extent that was set forth in this addendum. And it was something that Randy Gregory and his team felt was not advantageous to him, and he had another deal on the table for a different team, and decided that language was not in that agreement, and decided to pursue that opportunity as opposed to this one because of that contractual language.
Great. And Fernando Tatis, oh boy, here we go. Caroline, did you want to take us through this one? It's they could have, maybe should have. Didn't void the contract. Go ahead.
Yeah, absolutely. So they had initially agreed to this massive deal with him, and then he rode a motorcycle, I guess, and injured his wrist. And they could have likely decided to get out of that, or found a way to get out of that. They would have had to prove that he suffered the fracture during like a specific time period, but the timing was a little weird because there was the whole lockout. So they decided not to, and they came out with a statement saying that he's pledged to the team, to the club, that he will no longer ride on motorcycles. So he got out of that one.
Question is it ultra hazardous? I mean, yes, it's right. I mean, that's in there. And then, of course, the individualization of many of these contracts say that Myles Garrett can't play basketball anymore or whatever, because you don't want to get him, so that individuation, as it were, if they had a don't ride motorcycle clauses, which they do, it's not ultra hazardous by definition, but there's some cases in the book where ultra hazardous activities are referenced, and those for sure are void. We create a voidability condition. But you're right, Caroline, they chose not to. But he's out for the year now. He chose to have surgery. That's another interesting point we'll get to later, is his own, you always have a chance to go seek your own personal medical opinion. and decided on that basis not to have surgery that the team doctors had said he should have had. And now he's having the surgery now that he's out for the
And
year
is
anyway.
suspended for PEDs, and we'll refer to that.
Yeah, he's been suspended for PEDs,
Yeah.
right? That's why he decided to have the surgery.
Right.
Okay, and last but not least, Kyler Murray, he didn't have to do his homework. Well, come on, it's disrespectful, it's a joke, but Alexander, they only put it in. Why? You're working with a former GM in your placement. Why? They must have put it in for a reason, right?
I think it's the same reason that everyone thinks they put it in. I think they wanted him to actually do his homework, but the backlash to that and him complaining and all that prompted them to take it out. But I can't speak exactly for what the Cardinals were thinking, but I think this is such a unique clause that we can kind of guess what they were getting at here.
Yeah. Yeah. Okay. Well, this is chapters 1 and 2. Quick preview. You'll find this useful. And Caroline and Alexander will say when you get ready for the final exam way down the road, to just flip through this and see what, if anything, you find instructive. This will be in addition to that which we cover in our first class on Thursday, but we'll upload it. It'll be available to you. We'll announce when it's available. And we would recommend you could come to class for the first group hypo, having at least clicked through this quickly, so you get a feel for what the major themes are in the course. Anything else, Aaron, Caroline, Alexander?
Good.
All right. If not, we'll close this session and be back to you with chapter 3 down the road. Thanks.